on individualized facts and on a specific selection term. We also
saying
created an
that,
important mechanism to
today is
ensure
an
that the
important
FISA court
day,
hears
for
both
the
sides
city
of the
of
legal
Houston.
arguments
In fact, it
in cases
almost
presenting
seems
novel
every
and
day,
important issues.
is an important
And
day.
we enacted several measures to enhance
And this has
transparency of the
been
FISA court
an incredible
and in other types of
week,
reporting.
For the city.
At the end of this
I wanna
year, Section
thank,
215 and
the
two other
City
FISA
Council,
authorities,
for
known as the
today
roving
passing
wiretap
a
provision and the lone
unanimous,
wolf provision,
budget,
are set
for
to expire
21.
unless they are reauthorized by Congress.
And let me tell you,
Because these three provisions give the government powerful and controversial intelligence authorities, Congress former Director of National Intelligence Daniel Coates sent a letter to the leadership of this committee and other committees in the House and Senate asking that we reauthorize all three provisions permanently. At the same time, former Director Coates' letter acknowledged that the NSA has dismantled the call records program that had been conducting under Section 215 as amended by the USA Freedom Act. Simply put, the NSA dismantled the program because it was a serious failure. The NSA used it to collect hundreds of millions of phone records. But in 2018, it discovered that it had no authority to collect some of the records it was receiving. Worse, it had no way of separating out which records were wrongly acquired from the ones that were collected lawfully. So it started deleting them all. This has all been publicly reported by the intelligence community. To be clear, it is not a bad thing that the NSA identified a problem, told us about it, and tried to fix it. It is also fine that they decided the program was not worth running. As former Director Coates put it, the decision to end the program was made after balancing
into the $404 million in CARES Act funding. We can fund our parks, trash collections, libraries, and provide money to upgrade our drainage and streets. And the budget provides the service our residents expect and deserve. And so I want to thank everyone for their participation. Let me also say that today, over the past several weeks, in the aftermath of the death of George Floyd, while in the custody of Minneapolis police, people across the country and in the Houston area community have called for policing reform. And earlier this week, in fact last week, I announced that I was forming the Mayor's Task Force on Policing Reforms. I've also indicated, and what's been indicated, that the Committee over Public Health and Homeland Security, the City Council Committee, will be meeting next week with HPD, the chair of the Independent Oversight Board, I think even the District Attorney's Office as well, and starting those conversations as it relates to reform. But it is important that we take steps now in order to make the reforms, some of those reforms now, because it's important that we speak and act to the emergency of this situation. Also last week, 5 of our council members, African-American council members to be exact, put forth a letter also voicing some concern, some reforms that need to take place, and also calling for the signing of an executive order. Today, in a few minutes, that is exactly what will take place, that I will be signing an executive order 1-67. And let me just cover some of the things that will be included, that are included in this executive order. It covers response to resistance, that officers shall use only the amount of objectively reasonable force necessary to successfully protect themselves or others, to effect an arrest, or to bring an incident under control when dealing with members of the community, suspects, or prisoners, even if under the circumstances applicable law would allow the use of greater force. It speaks to de-escalation. Officers shall use de-escalation techniques to gain voluntary compliance and seek to avoid or minimize use of physical force whenever practical. and de-escalation techniques shall be continuously developed, updated, and made part of the continuing training delivered to all police officers by the Houston Police Department. Each officer should make clear the officer's intent to arrest or search a person and should identify himself or herself as a police officer before using force, unless the officer has an objectively reasonable belief that this information is already known by the subject or it is impractical to do so. With regards to the use of deadly force, prior to the use of deadly force, all police officers shall use appropriate de-escalation techniques that are reasonably likely to decrease the need for the police officer to use physical force. Exhaust all other reasonably available alternatives, such as, without limitation, issuing a verbal warning, when possible, prior to the use of deadly force. If de-escalation and all other reasonable means of reducing the conflict are not successful, the use of deadly force by means of a firearm is limited to those circumstances in which an officer has an objectively reasonable belief that the use of deadly force is necessary to protect the officer or others from imminent serious bodily injury or death. And police officers shall consider the immediate surroundings and the safety of uninvolved persons before using deadly force. With regards to shooting at a moving vehicle, a police officer is prohibited from discharging a firearm or soft impact weapon at a moving vehicle unless it is objectively necessary to protect the officer or others from imminent serious bodily injury or death. On notifications, in addition to notification requirements required by HPD's general orders, all uses of deadly force by police officers shall be reported to the Independent Police Oversight Board. Prohibited techniques. Police officers shall not use neck restraints or carotid artery holds, also known as chokeholds, whether by using an object or a body part, unless objectively necessary to prevent imminent serious bodily injury or death to the officer or others. Officers shall not place their knee, foot, or body weight on the neck of a suspect to control or contain the suspect's movement. With regards to no-knock warrants, police officers are prohibited from executing a no-knock warrant unless the warrant has been approved in writing by the HPD Chief of Police or his designee, the Chief of Police, and the warrant has been signed by a district court judge in accordance with HPD policy and procedure. And subject to the requirements of paragraphs 5.5.1, any no-knock warrant that may involve forcible entry of a building will be served by HPD's Special Weapons and Tactics Detail unless otherwise directed by the Chief of Police in writing. Body-worn cameras will be used by all officers who are members of the entry and perimeter team serving a no-knock warrant or participating in the execution of any such authorized warrant. With regards to duty to intercede, any police officer present and observing another police officer using force that is beyond that which is reasonable under the circumstances shall, when in position to do so, safely intercede to prevent the use of such force. Officers shall immediately report these observations to an off-duty supervisor.